or stay away from the line of questioning that would make him a professional.
Okay.
Your Honor.
Thank you. Have you formulated an opinion on the situation of Sarah Perez and Casey Perez as a whole?
I have.
What is this opinion?
It is my opinion that both Sarah and Casey Perez assumed the risk of injury.
In addition to your coaching experience, is there, if any, other affiliation with youth sports such as lacrosse or soccer that you have?
There is.
What is this affiliation?
My daughter played lacrosse all 4 years in high school.
You were the parent of a daughter that played lacrosse in high school.
I was, just like Casey and Sarah.
Based on your daughter's experience in youth lacrosse and your professional background as a coach, what is your opinion on youth sports such as lacrosse?
Objection, Your Honor. The question was, could you repeat the question? Could the counsel repeat the question?
What are you?
Well, what's your
objecting to?
objection? What's your objection?
At the beginning of the question, called for Mr. Durant to state his daughter's opinion.
No, I did not.
Yes, you did.
No, I did not.
It might have been a slip.
Based on your experience? No.
The beginning of the question was
I'm
your
going to
daughter's
let him
experience.
ask the question, and you can restate the question or re-ask the question, sir.
Based on your experience with your daughter's involvement in youth lacrosse, what is your opinion on youth lacrosse as a whole?
Well, the sport is very fast-paced, and rough. It's an outlet for injury.
As a parent with a daughter who played high school lacrosse, when your daughter was playing lacrosse, were you aware of possible injury?
I was.
In your opinion, should parents assume that there was a risk for their children to be injured in youth sports?
Absolutely.
What is your reasoning behind your? Are you being paid for your involvement in this case today?
I am not.
What is your reasoning behind your involvement in this case today?
My reasoning behind my involvement in this case today is that I simply want to get the truth out.
And what is that truth, sir?
The truth that Sarah and Casey Perez assumed the risk of injury as soon as they stepped on that lacrosse field.
Thank you. Thank you, Your Honor. Thank you for the questions.
Cross?
Yes, Your Honor. Mr. Durant, what degree do you currently obtain? Do you recognize this document?
Yes.
Your Honor, I would like to have this entered as Plaintiff's Exhibit B for identification purposes only.
Okay.
Mr. Durant, doesn't it state here, you can read along as I read this out loud, you have a college
Objection,
degree in
Your Honor.
mathematics.
The witness has not proven that that is their testimony by signature.
I withdraw the question. Allow me to rephrase. Could you confirm that this is your affidavit and that is your signature there?
This is my affidavit and this is my signature.
And please read along while I read this out loud. You have a college degree in mathematics. Isn't that correct?
Yes.
And Mr. Durant, are you a medical professional?
I am not.
Are you a doctor?
No.
Have you ever or are you currently a
Objection.
coach?
Your objection?
Relevancy.
I think it's very relevant because we're moving toward whether he has the expertise to be able to deal with, to make professional opinions. So I'm going to overrule that objection.
Thank you, Your Honor.
Mr. Durant, have you ever or are you currently a coach of lacrosse?
No.
And have you ever played women's lacrosse?
I have not.
And
I have seen 4 years of it as my daughter played throughout high school.
but have you ever been a coach of it?
No.
And isn't it true that you own a ski house with the defendant, Mr. Dempsey? Isn't that correct?
Only partially.
But you would describe your relationship as lifelong, as it states in your affidavit, correct?
I would.
No further questions, Your Honor.
Thank you, counsel. Redirect?
Yes, Your Honor. You said that you were affiliated with Shannon Dempsey, is that correct?
Objection, Your Honor.
Your objection?
Yes, no question. Can you ask that on Red Cross?
No,
Objection
read
should
the
be
rec.
form of the
Yes.
question.
One of the question.
The
One of the
objection
question.
is on the form, that's,
Thank you. Are you, allow me to rephrase.
sir.
Are you affiliated with Shannon Dempsey?
Yes.
Have you and Shannon,
I mean,
You
You
object
would,
again?
you should object again. You
I
should object again.
thought we were letting it go.
No.
No, no.
Okay.
Can you rephrase the question?
What if any relationships do you have with?
Your question is
Oh,
leading.
oh, my
You're
God.
open-ended.
what if any, relationships do you have, with Shannon Dempsey?
Objection, Your Honor. Objection, Your Honor. Asked and answered. Stated it is lifelong.
He has stated that, so I think that we can say that unless there's a different answer at this point.
I didn't say what.
Lifelong.
I didn't say that.
Well, it says it in your affidavit.
And it said it, it
You
said it,
agreed to it.
you agreed.
You agree, yeah. Have you and Shannon conversed at all on the topic of this case?
We have not.
Thank you, Your Honor.
Okay.
And, any recross?
No, Your Honor.
Thank you,
No, Your Honor.
thank you. Thank you, sir, I
Thank you,
appreciate
Your
it.
Honor.
Any further witnesses?
Yes, Your Honor. The defense calls Coach Dempsey, please.
Coach Dempsey?
I didn't do that.
Oh, okay. Swear to tell the truth?
Yes.
Okay. You may proceed.
Could you please state your name and occupation for the court?
I am Shannon Dempsey, and I am 27 years old, and I am the head coach of the women's lacrosse team, the Hornets.
And what, if any, experience do you have with lacrosse?
Well, I played at an elite private school as a walk-on all 4 years at Haught Academy. I played all 4 years of lacrosse.
And how did you become involved in this case?
I was hired by Jordan Reddick to fill in the position of the previous coach.
And what, if any, other jobs do you have alongside your coaching job?
I'm a gym teacher at a local junior high school.
And when you were hired to be the coach of the Hornets, what were the expectations for the team under your coaching?
I was hired to push the team a little harder. Last year, we made it to the state championships, the playoffs of the state championships. We lost in one of the final rounds.
And why were you trying so hard to go beyond your last season?
Well, it increases the chances of our players getting noticed by college scouts, and therefore increases the chances of scholarships.
And what, if any, training did you receive due to your position?
I was asked to take a SCLC safety course, and I don't recall any mention of concussions in that course.
And did this lack of concussion seem unusual?
No, because women's lacrosse is a non-contact sport.
And how did you come to know the plaintiff, Miss Sarah Perez?
Well, when I took over coaching of the team, I found out that she was one of the star players very quickly.
And did you ever have, or when if ever did you talk to the father of Miss Perez?
I talked to the father of Miss Perez when
If I may rephrase the question. What if any chance did you have to talk to Mrs. Perez's father?
I talked to Mrs. Perez's father, who strongly emphasized the need for his daughter to get a scholarship.
And what, if any, knowledge did you have of Sarah's condition from the prior season?
I did not know anything, nor was I told anything by anyone.
And when you were talking with Sarah's father, what, if anything, did he mention about Sarah from the previous season?
He did not mention anything.
And at the beginning of the season you were coaching, what, if any, forms did Mr. Parker fill out when the season began?
Mr. Perez?
Or Mr. Perez?
He filled out an injury disclosure form at the beginning of the season.
And what did that injury disclosure form say?
It had stated that his daughter had no previous health injuries.
And what, if any, unusual behavior did you see from Sarah while she was playing for you?
She seemed a little out of it sometimes.
And did this behavior cause you to worry at all?
No, I didn't worry at all because our workouts are very demanding.
And did you take any action based on this behavior that you saw from her?
Well, I can recall taking her out of the game one time, and I can't remember why, but I asked her father about it, and he said that it was probably stress.
And if I may direct your attention, to the day of the incident, how did Sarah appear on the day of her second incident in 2014?
She seemed a little tired.
And did you take any action based on this appearance?
Close to the end of the game, I took her out, and she did not object. She had no objection.
And what, if anything, did you do next after taking her out of the game?
Well, when it was nearing the end of the game, I decided to put her back in, and again, she had no objection.
And what, if anything, happened after you put her back into the game?
Well, she was running down the field, and she suffered a fall.
And was any action taken after this fall on your part?
The ambulance was called, and she was taken to the hospital.
And just to reiterate, how long have you played lacrosse?
I played for all 4 years at an elite private college.
And in your experience, how often do people fall in lacrosse?
Falling is very common, and in fact, it is very unusual for it not to occur in the sport.
No further questions, Joe.
Thank you, Councilman. Cross?
Yes, Your Honor. Mr. Dempsey, isn't it true that in your affidavit, when Jordan Reddick hired you, you quoted him saying, "Winning is what we are all about"?
Objection, Your Honor.
Listen.
Hearsay.
I'm going to sustain that objection.
Thank you, Your Honor.
I have
Yeah, I don't know how that would.
I have a question outside of this, if we could answer for a second. So, something weird. Anyway, when obviously when the judge says like you can't be argumentative at all, as in like you never get a chance to argue why.
May I be heard, Your Honor?
Yeah, is that a thing you can do?
You could, but it's not recommended.
Because I would argue that for the same reason that it wasn't hearsay in a similar situation with the plaintiff's other witness, Tobin O'Reilly, it wouldn't be hearsay in the same,
Okay,
you know.
well, let me do
similar
this.
It's an
Let
easy
me-
question to answer.
Let me let him proceed with the question, and then I'll make a judgment as to whether it's hearsay.
Okay.
Okay?
Would you like me to re-ask
Yes,
the question?
please.
Alright, isn't it true that in your affidavit, when Jordan Reddick hired you, you quoted him saying that winning is what we are all about?
Yes, he did say that.
Isn't it true that in the single class that you had to attend in order to qualify as a coach for the SCLC, none of the material covered had anything to do with concussions?
That is true.
Isn't it true that the SCLC, and by extension Jordan Reddick, did not inform you about Sarah's prior concussion?
No, they did not.
Were you not aware that the SCLC keeps a record of all injury reports submitted to them?
I was aware.
Yet, isn't it true that you never even requested to see these files?
Why would I? The parent signed the signature of their signing using their authority saying that their child had no previous health injuries, so I had no reason to look into it any further.
No further questions, Your Honor.
Thank you. And I'm going to withdraw, I'm going to overrule the objection based on the follow-up
Yeah.
questions,
Thank you, Your
because
Honor.
I just don't see that.
The short little tidbit to say that sounds very legal is that this is not going to the truth of the case, but merely framing the state of mind of my witness, or of the witness.
Because of time, okay, and because I have to teach a class at 6, what I'd like to do is have people do the closing statements, okay? Because I'd like Mr. Di Leonardo to hear those. So if you could, just speak right into the camera, all right?
Okay.
Can you do it?
I'm
Oh,
closing,
you're
but the
closing.
defense goes first.
Okay, defense?
I wanted
Just face the camera.
Just put that on.
Make like you're talking to Barack Obama or something.
Oh, may it please the court, Your Honor. What happened to Sarah Perez was tragic. But it does not mean that this tragedy should be placed at the feet of my clients. The people who only wanted the best for her, the people who looked out for her, and the people who wanted to make her the best athlete that she can be. But they cannot be expected to know more than her own mother and physician. In the case law, it is stated that in Kelly versus McCarrick, that coaches have a duty to, 1, take responsible steps to become aware of preventable risks to their athletes, and 2, must take measures to properly supervise and care for their players' safety. Your Honor, my clients are not negligent because they followed and did these two things. Coach Dempsey was not told that Sarah Perez had a prior concussion. In fact, he was even informed that she did not have a concussion because of the medical form Casey Perez signed and turned in to Coach Dempsey. Dempsey had no reason to believe that she had any previous concussion, let alone injury, and therefore took reasonable steps when handling the situation. Jordan Reddick also had done what he was supposed to. He made sure that the rules and regulations for injuries were followed very seriously. We even went as far as to fire a coach on the spot because he did not file his injury report on time in an orderly fashion. Jordan Reddick and Shannon Dempsey both took reasonable steps to prevent risk of injury. Your Honor, not only have we proven that our clients were not negligent, but also that the plaintiff assumed the risk of injury. Assumption of risk applies when a person knows and understands or must have known and understood the risk of existing danger, and voluntarily chooses to encounter the risk. Your Honor, we argue that Sarah and Casey Perez assumed the risk of injury. Though Casey Perez claims he did not know a concussion could lead to a more severe second, he should have asked anyway if he did not. This is called inquiry notice. Inquiry notice arises when a person is aware of circumstances which ought to have caused a reasonably prudent person under the circumstances to investigate and ask questions. If Mr. Perez did not know, he had countless situations to simply ask someone for information. He had noticed many things wrong with Sarah after her first concussion, from on and off headaches, doing worse in school, and generally being off. And he had multiple people and chances he had to ask someone about it, from all the neurology and head injury professionals around her at work to the pediatrician, but he never asked. Therefore, he should have known and understood the risk. He took the risk by not telling anyone his daughter had a prior concussion and still let her play. He filled out the SCLC's medical form, not indicating that she had a prior head injury, which she signed and turned in to Coach Dempsey. It is for these reasons we believe the plaintiff assumed the risk of injury. Your Honor, though this was a tragic event, this tragedy should not be placed at the feet of my clients, the people who only wanted the best for Sarah Perez. By a preponderance of the evidence, I ask that you find my clients not negligent. Thank you.
Thank you, Counsel Wilmot. Mr. Collins.
Your Honor, today we have heard the case of Sarah Perez, who has been left extremely disabled due to the negligence of Shannon Dempsey as well as the entirety of the SCLC. During Sarah's lacrosse career with them, the SCLC repeatedly, through their inaction, committed one act of negligence after another. Your Honor, negligence can be described as not doing something that a person using reasonable care would do. Reasonable care, Your Honor, means the caution, attention, or skill a reasonable person would use under similar circumstances. In this case, Mr. Perez and the SCLC were presented with numerous opportunities during which they could have taken action to secure the safety of Ms. Sarah Perez. Mr. Dempsey himself testified today that the SCLC has files on record, files that documented Ms. Perez's injury that he could have reviewed at any time but chose not to. During the entirety of Sarah's second season, Mr. Dempsey and the SCLC, due to the paperwork received from Mr. Tobin O'Reilly, were aware of Sarah's previous head injury. This means that every single day Sarah played for the SCLC and Mr. Dempsey, they were being negligent. It is the plaintiff's assertion that a reasonable person with possession of this information will review it and never let Sarah continue playing. As Mr. Bobby Chadwick testified to, Once an athlete suffers one head injury, any future injuries are simply too dangerous for the safety of the player. Mr. Dempsey, and by extension the SCLC, simply should not have let Ms. Perez play, and every day they did was a day they committed negligence. Your Honor, we are also aware of the possibility of assumption of risk in this case. As stated in Kelly versus McCarrick, when it comes to assumption of risk in sports, a voluntary participant in any lawful game, sport, or contest assumes all risks incidental to the game which are obvious and foreseeable. Your Honor, while falling may be common and may certainly fall under the category of obvious and foreseeable injuries in any sport, collisions with another player are not when it comes to non-contact sports. Ms. Perez did not assume the increased risk that followed her first injury with a collision with another player, as that is, by definition, not obvious and foreseeable in a sport that forbids contact of any time. On the subject of contact in girls lacrosse, the defense seems confused on their stance. While Durant says collisions are common, Coach Dempsey asserts that the SCLC's girls lacrosse is a non-contact sport. Your Honor, this case is about a young woman whose life has been completely destroyed by a tragic incident that occurred while she was under the care of Mr. Dempsey and, by extension, the SCLC. It is apparent to the plaintiff, and hopefully by now the whole courtroom, that the SCLC cares nothing for Sarah Perez, as they refuse to take any level of responsibility for the injury of a player that was under their care. What the SCLC does care about is winning. When Mr. O'Reilly was hired by Mr. Reddick cared nothing about safety training, his certification, or even his history with coaching. He cared only about O'Reilly's winning spirit. Sarah was the star player of her team, Your Honor. The SCLC didn't care about her safety. They're certainly not taking any responsibility for her or showing any concern for Ms. Perez's injury. They cared only about what she could do to help their team win. The SCLC's negligent valuing of winning over the safety of one of their own players is what has brought us here today. And for this reason, Your Honor, my counsel and I ask that you deliver a verdict of guilty on both Mr. Shannon Dempsey and the SCLC. Thank you, Your Honor.
Thank you. Okay, I'm gonna give that card to Ryan. If you could give your dad a call tonight? And just ask him if he can get this, okay, from you. If you can't, bring it back to me tomorrow, okay? If you bring it back to me tomorrow, what I'm gonna try to do is put it on Google. I can probably upload it onto Google, one of the Google platforms. I'm gonna try to get it to him this way first, all right? If he says that he can get it before Tuesday, or before Thursday, that's fine. All right, if he can't, bring it to me tomorrow morning. Fair enough? Good job, guys.
If I can get it to him Wednesday, that would be fine.
I'm sorry?
If I can get it to him Wednesday, that'd be fine.
Yeah, tomorrow's Wednesday, right?
Sorry.
Yeah. If you can get it to him, if he can pick it up Wednesday or Thursday, that's fine. Okay? If he can't, or not sure what's gonna happen, somebody help me out with this thing. How did you turn it off?